So without further ado, I would like to bring Elaine and Lana forward.
I call this section federal overreaching. And there's just a few points I'd like to cover, and then I'm going to ask Lana to talk about what's moving in the courts. And then we're going to kind of segue into Q&A, and we will close the conference with our wonderful Rick Jor, who's going to come up with say a few words and then give us an invocation. Here's something I wanted to talk about. I mentioned earlier this treatment as states, and this EPA Federal Register notice that is out that is reinterpreting congressional intent. I had spoken earlier about this cooperative federalism that is now between the United States and tribes, elevating tribes above the federalism of the United States and states. This reinterpreting of congressional intent is spelled out in a 12-page fine print, 3-column Federal Register notice in EPA that came out in August. I've already submitted comments for the Village of Hobart, and there's an October 6th deadline. I hope lots of other folks comment. It is just disgusting. The EPA experts reanalyzed old court cases, and they drew phrases from dissenting opinions, not even the majority or the actual ruling. They drew some phrases from dissenting opinions of old court cases, and then they gleaned through the congressional statutes of the 5 environmental acts and looking for little catchphrases that would support their reinterpretation. And what they've done is they have interpreted, EPA has, this is not with Congress's awareness or approval, but they have reinterpreted that Congress always intended that Indian tribes govern all persons on their reservations, non-tribal persons and properties as well. This is the new EPA Native American policy. They just figured out that Congress always intended for tribal governments to govern all persons on the reservations. That's how arrogant EPA has become. That was supported, and we'll have Larry talk about it, in one of the rulings on the legislation that we have, on the legal action that we have in D.C. There's a FERC judge and a DOJ legal counsels that came back with some language in a motion to dismiss, and they had the arrogance, this is all revising history, they said that the Dawes Act and the Homesteaders Act, that Congress breached the Hellgate Treaty with the Dawes Act and the Homesteaders Act. You know, now, one of the lies you constantly hear is the treaties of the supreme law of the land. That is 1/3 of the supremacy clause. The first part of that supremacy clause is 1, the U.S. Constitution, 2, the laws of the United States Congress, and 3, treaties are the supreme law of the land. But you only hear the Indian industry, by that I mean the lobbyists, National Congress of American Indians, tribal leaders, they'll only say, oh, treaties are the supreme court of the land. Don't look at the whole sentence. Don't look at what comes first, like the Constitution. So now we're hearing in 2015, even by DOJ and FERC legal counsel, that Congress always intended that tribal governments have control over governance over non-tribal members and persons, and that those old congressional acts breached those precious dead treaties. This is, Carol Lyons brought me this morning. I'm going to have an electronic copy made. It's a wonderful brochure, and I'm going to have to find the date on this. Pretty certain it is, but it must be consistent with the Homesteader Act. It's a big brochure that says, Uncle Sam will give you a home. You know, along with the Dawes Act and the Homesteader Act, and it's all about Montana, and it's all about the Flathead Indian Reservation, opening it up to homesteaders. Marvelous old booklet with photos. Cameras were around then, so it's got to be the 1900s. So I guess the deal is, when Congress said, go west, young man, and he went west with nothing, except what he could get in a wagon, and going west, young man, homesteaded some bare land, made it, irrigable, built a home, built a community with his neighbors, built the schools, built the towns, settled the West. And the federal government gave them nothing but the opportunity to improve a bare piece of ground and water attached to it. That's all they got. Now, when Congress, President Franklin Pierce sent the Washington Territorial Governor Isaac Stevens out to execute all these treaties out here, tribal cultures were given money, blacksmiths, doctors, schools, housing, clothing, they were given the basic needs every year, and they still are, in spades now. So, but who settled the West? We did. And you have this present administration saying, oh, that was all a fraud. Congress never intended,
You didn't build that.
You didn't build that country. You didn't settle the West. Thank you, Butch. You didn't build that. That's really the mentality. That's really this huge shift that's coming from the executive branch. And I wanted to point that out. Just one other thing we currently have, 566 tribes. Some of them have taken 10, 15 years. The criteria for federal recognition is strenuous. Recently, Kevin Washburn, one of my least favorite individuals, the BIA Assistant Secretary, has collapsed all that recognition process. He wants to make it very easy for waiting tribes to be recognized. In 2014, the General Accounting Office, which is our national auditor, published a list of 400 tribes in the country waiting for federal recognition. Now we have 566 that we are annually funding, and they want to hurry up and recognize 400 more. And Washburn's goal is 50 a year by collapsing the recognition process. So it begs the question, what is a state's carrying capacity? Let's look at the worst poster child, Washington State. Washington has 31 tribes, and they have several more tribes that want recognition. 31 tribes. Now, if they get that many more, what is their carrying capacity in terms of carved out land for reservations, in terms of federal trust land, in terms of the Salmon Recovery Project, which gives those tribes almost total control of Washington State's waters, and all the tribal casinos, they each get 5. 31 tribes each get 5 Class 3 casinos, thanks to former Governor Gregoire. There's only 5 or 6 large towns in Washington State. What do you think is the financial stability and carrying capacity of a state's economy when its taxpayers are burdened with supporting 31, 40, 50 tribes that are all in tax-exempt businesses, that are cutting government checks to the elected officials of that state? It's pretty foul. It's just amazingly foul. But one of the biggest concerns, and this kind of ties a lot of pieces together, including Debbie's presentation, Agenda 21, what's moving in federal Indian policy. I didn't bring a handout, but if I were to draw a wiggly line on a blank piece of paper, I might call it the Colorado River, or the Columbia River, or the Missouri River, one of the major rivers. And then I draw an arbitrary kind of a boundary, a circle, around that river. The U.S. Army Corps of Engineers, along with Fish and Wildlife, BIA, all those federal king's horses, have created these major watershed management plans for the major river systems. And in their early formation, they were about the public interest. And they were to manage all the little rivers and streams and tributaries that come into the big river, But as you heard earlier, most of the energy and power systems that were installed in the West as the West was being settled were put on in near Indian reservations. So if you can imagine that squiggly Columbia River or Colorado River, great big watershed boundary, and then picture dams and major river systems, and then picture Indian reservations, and that's the watershed management area of the major river system. The priority of that those watershed management systems have shifted from the public interest to tribal self-governance.
Wow.
And the priority of the water management is to protect fish and wildlife habitat and the endangered species. That's the other priority. And the next one is sacred and cultural resources. This is the watershed management plan for every major river in the western states. And then it gets down to, further down the list, recreational use of water. And then there's the language that they will strive, trying is lying, strive to provide irrigation. What's in the middle of this system, whether it's the Colorado or the Missouri or the what? Or the Flathead River or the Columbia River, what's in the middle of all these watershed management areas is America's food. Is our food production. You have a current administration using the federal agencies, delegating their authority out to tribal governments over everybody and over all things, and implementing these kinds of plans that is now coming, killing the healthcare wasn't good enough, and now taking down the power and energy systems, transferring those into private governments that have no duty to keep us safe, transferring the power of our energy and our power plants to tribal governments that have no duty to you and me in this country, and controlling whether or not a farmer has his water or a cattleman has his stock water, controlling the water. And that ultimately takes down the food economy, the agricultural and the food economy, and all of those agricultural areas that have little communities and little counties that don't have big fat budgets. You know, when your farmer and cattleman go into the feed stores and the grocery stores and whatnot, they support the county government. Your city governments and your small businesses that support that ag industry are not going to have their buyers anymore, their consumers anymore. So it's not just the food, it's the total economy of the local counties. So when you look at these things all put together, we really need to get noisy. We really do need to stand up, as Debbie said, and we really need to stay noisy, and it's no darn wonder they're trying to shut us up. So good, have at it, let them. So those are the little things that I wanted to point out, and I'm going to have Lana, do you have some
I want a copy of that.
of this? Yeah, absolutely.
Are there any more of those?
I'm going to have, I just got it this morning. Carol gave it to me. I will, what I'll do is, it's called Uncle Sam Will Give You a Home. And I've got a card around here, floating around here somewhere, but I'll get an electronic copy made. And
Oh, she's got it now.
I know Lana's going to steal it.
I am not going to steal it till you copy it.
Okay.
Bridge, 2.5, 3 years? Not right in there? Yeah. For the most part, is the federal government literally just sort of backing down, which is in some ways no fun. So we've got a lot of pending decisions, just a huge amount of things that are just sort of waiting in the wings, waiting for us to be able to do something. It's also kind of brilliant, though, in terms of the strategy, because the federal government was pushing the promotion of tribal sovereignty enough that they gave us opportunities to fight back, like feed a trust, okay? And then we started winning, and so they back off of pushing. Well, that puts us in the position that for us to continue to win, we now have to sue them affirmatively. And I'll be honest, folks, it's a lot harder for us to sue them than it is to respond to a lawsuit they've filed against us, okay? And there's a really simple reason for that any lawyer can tell you. If you're the ones that sue, you bear the burden of proof to prove your position before the other side even has to answer, okay? So now we have to turn around, and this is actually the situation now on the Animas River. We've come up with all these wonderful ways to defend ourselves. People were talking in here about how when Cera got started, we had to establish the standing to be able to go back and actually fight the federal government in court. We had to change Rule 11, which is the sanction rule. Lawyers are not supposed to lie to federal judges. Well, there's a concept for you. You know what? When I came out of law school and the first 3 water cases I got involved in all 3 of them I realized the federal government was lying through their teeth. But at that time, Rule 11 didn't apply to any federal attorney.
Whoa.
We actually had to get the rule changed so that a federal attorney lying in federal court could actually be sanctioned and actually was held to account. This is not a joke, okay? So, you know, we ended up over the first 20 years, okay, have literally been spent getting the rules to apply to the federal government and giving us the right to actually stand up when they sue us and actually have the right to defend ourselves in the courtroom. Which sounds crazy, but it's really true. And standing has been the huge issue. Economic harm, we could just detail one after the other, okay? The point being that now, and there are a bunch of people here from Klamath, Siskiyou County. You know, we won that standing argument. I actually was working with the main counsel for the plaintiffs back there from San Francisco. We won Bennett versus Speer. You got to remember that before Bennett versus Speer in 1996, excuse me, we couldn't fight back. We literally had no authority to fight back.
What was the essence of that rule?
The essence of Bennett versus Speer, and it's critical, so thank you for asking the question. There was a doctrine there still is a doctrine called prudential standing. If you look at what Richard Nixon did in passing all these environmental laws in the 1970s, remember Nixon is the one that takes this conspiracy I was talking about earlier and takes it exponential. He applies it to everything the government's doing. What they actually did in the way they defined the laws was to say, this is the federal interest. And so these are the interests that the United States is out to protect. And if you actually go into whether it's the Endangered Species Act or the Federal Land Policy Management Act or Clean Air Act, Clean Water Act, you get the idea. They all have a set of federal interests that are to be protected. And then they actually designate the groups that have the right to enforce those interests per the way the Congress has designed the bill. And until Bennett versus Speer, unless you were promoting one of those federal interests and were one of those groups designated in the law, you could not even object to the passage of that law or the application of it against you.
Wow.
And in Bennett versus Speer, we turned the tables. And it was no longer what Congress had said as to what was going to be the only thing that a court could hear, because what they did is they cut off judicial review. By cutting off our standing, they cut off the ability of a federal court to say, hey, you have the right to be in here and actually defend your property. Okay? So that's one of the reasons you didn't hear about these suits before the 90s, because you couldn't do it. The government would come at you, and you basically better either negotiate or roll over, because you didn't even have the right to fight back. Okay? I mean, that's how bad it was. And that's how effective this policy was when Nixon put it into effect. It was incredibly effective. Now, then the bureaucracy, of course, kept expanding and going further and further and further, right? So now what we're in the position of having to do is actually come up with affirmative ways to fight. And so we almost are back at the drawing board a little bit, because I'm going to give you the ultimate example of this at the moment. The spill on the Animas River. Now I'm licensed in New Mexico. And the spill happened in Colorado, and immediately came across the state line and affected New Mexico. It also affects Arizona. Okay? If you look at the big harm that is caused by the Animas spill, It is actually New Mexico that actually bears the big part of the harm. And that's just because of the fact that Durango is up the hill from the spill. And it's the cities in New Mexico that are directly affected by that at the Four Corners. You know, Bloomfield, all of that, right at the Four Corners, that are really, really hurt by this bill. It's also the Navajo Agricultural Products Group, which is kind of a joke, so I don't think anybody's going to sue over that. The federal government set up a huge water project for the Navajo Nation. They call it NAPI. The problem is Navajo were never farmers. And so the project has been run by the Ute Indians for many years, and I'm not sure the federal government has the audacity, or anybody has the audacity to sue on behalf of a project that's never really been used. But, you know, so that's not going to happen. But the towns have been really affected because this is a very dangerous spill that has come down the river and very much affects the drinking water and all the things that have to do. And you know, that river, the Animas River, joins the San Juan right in the town of Bloomfield. And so that literally washed right into the town. Okay? So here's the thing. We've established standing to defend our rights. How do we establish standing now to sue the federal government when they screw us over by over-regulating us? Okay? It's not a funny thought. Yes, sir?
I'm not even an amateur at this, but wasn't there a Supreme Court ruling recently that concerned the fourth, which said you did not have to have injury to establish standing, and you could perhaps make your case with a facial claim?
Well, now, you gotta be a little careful because that's not quite what it says. Okay?
Fix me up.
They expanded takings law to include chattel property. Now, this is the big raisin case. This is the raisin growers case out of California. And I'm trying to say the name. It eludes me at the moment. It was against the Secretary of Agriculture. But if you look at that new decision, they expanded takings law for the first time to apply to non-real property. Okay? It's a major decision, you're right. Yes, we may be able to use that to some extent because it is right down that line. But here's how far the law has slipped in terms of constitutional law and what's happened. We are supposed to be the supreme sovereigns the way this government was designed. We are. The individuals, we the people, are supposed to be able to control our government and hold them accountable. Okay, and I'm sitting up here and telling you, and I have done as much, if not more, than almost any attorney in the country in breaking the law, or turning the law around. I can't tell you how we would sue the federal government at the moment. Okay, over the Animas spill. I honestly can't. Now, Horn, that's right. Yeah, thank you. Horn versus Vilsack? Yeah, but it was the Horn decision. Yeah, it was the raisin decision.
Excuse me, Lana, are you saying that none of the harmed communities like Bloomfield have any standing to sue the feds over that spill?
Yeah, well, it's not that we don't have standing. It's the federal government claims sovereign immunity. Okay? Since the Civil War, the federal government's claimed sovereign immunity. Oh, by the way.
How about officials?
Well, now see, that's where this gets interesting. But you were dealing with the same laws that we had to deal with to withstanding in Bennett versus Spear, where the way they were designed, Congress laid all this stuff out, and now you've got to go back and say, well, that law doesn't apply. Well, I'll tell you, there may be a way to do it. And that is by raising an equal protection argument. There may be an actual way to do it by raising equal protection. But the fact of the matter is, guys, I mean, there is nothing easy about this stuff because the federal government has so overreached. And in using the war powers, it's established its own sovereign immunity. And if it doesn't say on the face of something that there's a waiver of that federal sovereign immunity, By the way, before the Civil War, the federal government was not deemed to have any federal sovereign immunity. Any citizen could sue. Did you know that? Before the Civil War. The federal government was deemed to be the government of the people. That's that 14th Amendment part. And it's not until after the Civil War, or it's actually during the Civil War, frankly, that is the first time that the federal government asserts sovereign immunity to prevent its own citizens from holding them accountable. Okay? So we actually have to figure out a way to either expand the Administrative Procedures Act, because there's no suit on the animal spill under the APA. There's no easy suit. There's no obvious way using the Administrative Procedures Act to sue. Okay? There's no way under the Federal Tort Claims Act to sue. Those are the two big waivers of federal sovereign immunity that the government has given us to be able to somewhat sue them. There's no way necessarily to sue in the Federal Court of Claims, which is actually the court that the federal government created. It's the only court you can sue them in when they're using the war powers. Now, the one chance we really have to sue them over the animus spill is in the Court of Claims. If we raise the right kind, if we can actually get really clever and figure out how to get in the Court of Claims, because it's the only place we can sue them when they're using the war powers. Okay? And it was set up that way from the Civil War. But the jurisdiction of the Court of Claims is not an Article III court. It's an Article I court, specifically set up by Congress to protect the sovereignty of the United States. It's an Article I court, like a true military court. All courts martials are Article I courts. So the only chance we really have to sue these, I can't say that word in here.
Yes, you can.
Yeah, well, you know what I'm going to say anyway. Yes. The only way we can really sue them, based on how the law has been abused, is by trying to figure out a way to use the Court of Claims. Now, that is how we got some of this going. That is the way we, in fact, Rule 11, some of these changes, we actually did these big federal Court of Claims actions to get the law changed. So now that I've given you the negative, let me give you one last positive and then I'll quit. So I'm weird. I'm looking at my timekeeper. As I say this, and just to give you an idea just how big this is, I must tell you that the federal government made one mistake, a pretty big one. We're not sure exactly how it happened. We're actually kind of thinking it might have been one of the justices of the United States Supreme Court talking to a judge in New York State over what I'll call the bigger Oneida picture, the one that's been going on since 1970, where the Oneida tribe of New York sued the state of New York to try to reestablish a land claim that had not existed, and this is not a joke, since 1803. Okay? So in 1970 they sue when there hadn't been an Oneida Indian reservation in the state of New York since 1803. Not a joke. Okay? We actually get the land claim cases completely dismissed. Okay? That's the City of Sherrill ruling from 2005. Even though there are no land claim actions still in existence in the state of New York, the federal government somehow decides it can take land into trust based on these land claims 2 years ago for the Oneidas of New York. No land claims in existence anymore, completely killed in the courts. And they moved to take federal land into trust based on the land claims. This is not a joke. I can't make these things up. The federal government can outdo my creativity at every turn. Anyway, because they did this, and Cera had actually brought suit, and we challenged, well, this is the case where we had actually challenged the authority overall of the Secretary of Interior to place lands into trust. Now let me just explain this real quick. The ability to take lands out of state jurisdiction and actually remake them into federal Indian territory or federal territory and give them back to an Indian tribe is everything we have been talking about today in terms of this power from the Civil War and fruition. Whether it's the maintenance of the public lands under FLIPMA, almost all of it. the microcosm argument of the power of the United States to be able to change all our rights happens in a fee to trust suit. Because that's the claim. They're actually claiming that they can go backwards. Instead of having disposed of the territorial lands, they're actually claiming through the reserve rights doctrine, okay, if you actually follow their reasoning, oops, we made a mistake, it never should have gone under state jurisdiction, now we're going to take it back. And the promotion of tribal sovereignty, what Elaine was just talking about, if your basic argument is we never should have taken this from the Indians in the first place, by the way, we never would have had a country if we hadn't taken it from the Indians in the first place, but details. If you actually play that out, it all happens in fee to trust, okay? I mean, it's a true microcosm of the whole big picture. In New York State, Cera actually, as a plaintiff, challenged the secretarial authority from every direction we could think of and said, you know what, guys, you don't have the power to do this. The government actually came back and cried foul that we introduced documents that had been purged out of their files and actually introduced them back against them, showing that they had said previously they didn't have any power to do this. Isn't that a joke? The judge initially ruled in the case that the government had to be right, and because we had not submitted everything we had found for the secretary to be able to address, that we had to lose. Okay? So we turned around and said, that's the craziest damn argument we've ever heard, because the government concealed and purposely got rid of all these records. We've got a Rule 11. Okay, we'll bring it as a Rule 11 sanction. Because now, they're the ones who lied and you're hurting us? Okay? You've been lied to for 35 years back here and you're blaming us? Give me a break. Okay? So anyway, we go through this, and finally the judge dismisses our case. Okay? After we've laid out all that conspiracy theory I talked about this morning, we actually laid it out in this lawsuit in New York. We actually put it on paper and laid it out and said, the Secretary of Interior has no authority to put lands into trust, period. Okay? And lo and behold, when he wrote the order dismissing the case, he did the very thing that we have been looking for the last 20 years. He gave us the actual federal statute from 1966, where they claim to be able to take these Civil War powers and actually reinstate all of that authority that was under the Civil War and use it against us today. The part that was repealed originally by the Dawes Act gets brought back in 1966 in the Medicaid statute. We had been trying to find this thing. We knew it was out there. We knew it was our primary target. Okay? And lo and behold, Judge Kahn, because of the argument we presented and how nasty this thing had become, and also, by the way, that case has gone back and forth to the U.S. Supreme Court 5 times. Okay? So you talk about one that the Supreme Court's kind of interested in. And lo and behold, there it is. Pop goes the weasel. Okay?
How did he find it?
Huh?
How did he find it?
We think, we're not sure. We don't really know. But we have 2 different theories, and I'll just give them to you real quick. One, the Supreme Court has been getting more and more interested in this, especially because of this case in New York where this thing literally is bouncing back. And the last 2 times this case was accepted by the United States Supreme Court. This is in the last 10 years. There has been some federal manipulation so that the Supreme Court could not hear it. It's been accepted, and then the DOJ or the tribe or somebody has pulled some kind of garbage so the court couldn't hear it. And they're pissed. I mean, they're just plain pissed. And so it could have come from Justice Ginsburg, that they actually had found this. Because Cera has been saying this in brief after brief after brief, most lately in the Village of Hobart briefing. And so it's possible that we know that Judge Kahn, the district court judge in the case, is a very good friend of Justice Ginsburg's. And they get to talk. You know, we can't talk to the judges like that because they cry foul. But the judges can talk to each other. Okay? So that's one possibility. The other possibility is that his new law clerk, because this is the northeastern district of New York. His new law clerk just graduated from Harvard University. And it's very likely that we were getting close enough to pushing on the truth, shall we say, that Harvard got defensive enough, because Harvard, by the way, wrote the Reconstruction Acts that Lincoln didn't want. If you didn't know that. Harvard University wrote them for Edwin Stanton. This is not a joke. You look that up. We think his law clerk may have actually called one of his old professors and actually gotten this thing that we have been looking for forever. Okay? And literally, Cera has been looking for this. We have known that this thing had to exist for 20 years now. But it's like looking for a needle in a haystack. Okay? So, order comes down in March. We have 10 days in which to file a motion for reconsideration. We got our motion for reconsideration filed, and we literally have the issue of whether or not the federal government could use the Civil War powers to bring back all of this Indian policy today before the court. The federal judge, within 2.5 days of receiving our motion, challenging this absolute statute that he said was the basis of the secretarial power, is this Medicaid statute. By the way, passed as 43 USC 1743, I think it is. Don't quote me on that, I gotta look it up. But it's 43 USC, that's the public lands title. How was a part of Medicaid adopted under the public lands title? Okay? Yeah, no joke though, this is really going on, okay? So now, 3 days after we submitted our motion for reconsideration, Judge Kahn ordered the United States to respond. A motion for reconsideration against a dismissal order is not worth the time of day unless the judge actually tells the other side to respond. Okay, then the motion basically goes live. Now you can use it to kind of bring issues to the appeal, but it doesn't really, you're not going to get a decision on a motion for reconsideration unless the judge says, other side answer. Okay? He orders the United States to answer 3 days after he receives our motion for reconsideration. That's why we kind of think it was Justice Ginsburg that did this. The government, instead of waiting their whole 3 weeks to answer, he gave them 21 days in his order to answer. They answered the day the new Attorney General was approved by the Senate of the United States, 7 days early. You know, when do you know of ever, if ever, of the federal government finding anything early? It does not happen. Okay? So they didn't want the new Attorney General, who by the way is from New York State, is an expert on fraud, okay, to see this. They had this off their desk and out before she was actually confirmed by the United States Senate. The very day that she got confirmed, so the day before she takes office, okay, they have this thing out. And you know what it says? Tough crap. We are the federal government. Try to stop us. And federal judge, if you think you can actually make a ruling that would stop us from doing this, we want full briefing. And there it sits. Okay? So, while I'm saying that nothing is moving, we have actually taken everything that I was talking about this morning and actually have it up in the courtroom in a case that will go expedited to the United States Supreme Court the moment something happens. So, don't lose heart. Life has gotten very amusing. So, they tried to stop up everything. And then for whatever reason, just as they're trying to stop us from asserting anything, they make the biggest mistake they could have made. And pop goes the weasel. So we'll keep you all informed. But it's really fun times at this point because no matter what happens, see now the issue's fully raised in the lower court. So no matter what happens with this ruling in the district court in New York, this thing is going like a lightning rod to the United States Supreme Court. And it's perfect timing because by the time you run it through the appeals process and go through the Second Circuit, guess what? We're going to have a new president.
Yeah.
Okay, by the time it hits the U.S. Supreme Court. So we couldn't be more thrilled with what's going on. So don't lose heart. If we win this motion, if we actually won this, almost the change that would occur in law would be stunning. Okay, it will be stunning. So go ahead.
So if I want to follow this decision, what do I look for? I mean, what's the,
You know, Larry wouldn't put
headline?
this on his website, little rat. If you want to follow it,
That actually was in a published article.
yes, yeah, in a published article. There's actually being, this has actually made the government, it's on the Cera website. I think it's on the Cera website. Did we put it on our website?
Actually, Canada Free Press has published the article.
Canada there are people who have picked up on this is going on. Cera did not make a big deal about this.
But what is this? Just give me the words.
This is the Citizens, it's Fair Business, Central New York Fair Business, that's the group that belongs to Cera, and Citizens Equal Rights Alliance against versus Sally Jewell. Eastern District of New York, and I don't remember the case number right off the top of my head, which I should, but
Thanks.
if you look that up, you can actually pull this up. It's not a joke. We actually have the authority of the federal government's, the actual authority to do all this stuff, actually in court, and we're actually challenging it.